Now, one-to-one services. The thing that typically parents want is to escape a generic program, because in my opinion, that's one of the worst things that happens to our child. You know, you guys are going to go to all sorts of presentations during Autism One, and the thing that's going to be said over and over and over is how all these kids are so different. Well, then how could you put them all into the same special day class, okay? I bet my son isn't the same as any of your children because they're all so different, okay? So that's one of the reasons why, even if you're never going to go to due process, your children would benefit by an independent evaluation, because anyone who works for the school district or a state agency typically has a conflict of interest. It's their job to fit your child into an existing program, not to determine what your child's true needs are, okay? So you need that information to escape the generic program. And that generally is what I'd like everybody to have, is a one-to-one behavior services. And I'm calling it one-to-one behavior services because I'm not saying it has to be ABA or verbal behavior or floor time. It needs to be what's appropriate for your child. And I'm not even going to say that eclectic is necessarily a bad thing, because you might have a really talented behaviorist who can put together a really great floor time, PECS, something else program. Okay, the other thing about strategy is sizing it up. Do you have a good case for pressing forward for what you need, okay? And this is really important, whether or not you intend to go to due process, because since you're going to play poker, if I were consulting with you, only you and I and your spouse or whoever is important in your life is going to know whether you'd ever really go to due process, because you can't really effectively negotiate with somebody else if you've already told them what you will and will not do or how much money you have to spend, okay? We're going to bluff it, because there are parents that there's just no way they could ever afford to go to due process, but we're going to act like they're going to do that. How do you determine if you have a good case? Sometimes the best thing to do in the beginning is just invest in a file review. You can pay a lot of attorneys for a flat fee, and it ranges. Some attorneys have told me $250. Some of them tell me $800. Well, what they will do is you will gather up every piece of paper associated with your child, and they'll do a file review, and they'll meet with you once to tell you where is your child from a legal perspective. Do you have a great case? Because a lot of times parents, even me, I've looked over, I just brought actually a file review to share with Dr. Perlman and with Tim. And you look over it, and it's crazy, the stuff that happened to this child, but the parent doesn't realize that. She doesn't know what kind of case she has. So you can kind of figure out what you're going to do based on, do you have a good case? And then by the experts. Dr. Perlman talked about a really important point, what the file tells you. He could tell you, well, you know, didn't you notice that 3 years ago that they said this, but then they said this? Did you not know, you know, which is not your fault. There's a lot of overwhelming information. So you can have both your expert and attorney say where it is, which will put you in a much better place of knowing what your choices are. Okay, what are your chances of prevailing for what you want? And then it'll help you to prioritize your spending depending on what it is, because I'm guessing that, like me, most of you do not have an unlimited amount of money to spend on your child. So if you consult with this experts, we can talk about what are the things we're going to spend the most amount of money. If you have, you know, maybe you decide, you know, talk to my husband, we can take equity out of our house, but max it's going to be $20,000. And I talk to my parents, or whatever that money's going to come from, or I figured out how much we can leverage in credit cards. We can figure out how much of that should be with an attorney, how much from the experts, which are the really important evaluations. You might be some, you're going to go totally private pay because you want the best person. Some of them, maybe speech isn't that important to you, so we're going to go ahead with whoever your insurance will cover, okay? Because at this point, I'm assuming we don't know that your district is going to pay for the independent evaluation, but I want you to get it. Okay, and then the other thing to remember, easier to overcome the bad program versus the mediocre program. And I had a hard time with this because when we started my case, because Dr. Perlman was the independent evaluator for my son, I wanted to fix things all the time. I wasn't really good at any of the things that we're talking about here. And I was always complaining and wanting to fix things in the school district. And he kept reminding me, stop trying to fix it, okay? If you're going to go to due process, you got to leave things the way they are. Okay, let them have the total crap program that they want, but balance it. Because remember, Tim also said, but that never let your child get hurt by it. Okay, so you got to balance that out. Sometimes you can let crap happen at school that really has no, you know, if it's assessment, it's not going to really hurt your child to have a bad assessment by the district. It wouldn't mean that I'd say put your child in a really horrible placement that you think might cause them to regress. I don't mean that. Consider back doors, okay? It depends, and you're all from different states, who your state agency is. Sometimes people are overlooking what they can get from the state agency, because a lot of times what I want parents to do is, your district won't give you an ABA program? Have you tried getting it from your state agency? Because let's start there, because sometimes that's easier. And I'm not saying that that can make up for it, because typically your state agency is only going to address your child's non-educational needs. But the thing is, if we could do that, if we could write a letter to your caseworker and identify everything that's non-educational, everything typically under health, safety, and self-help, if we can get an ABA program going at home just for your state agency, well, first of all, we can prove that ABA is effective for your child, because we can see what the difference is. Also, it means all of a sudden you have a behaviorist on your case, somebody who go to your IEP and help you to improve your program. So you have leverage that you would never have had otherwise. Okay. This is another part about playing poker, sizing up the opponent. We need to know more about your district, because, like I said earlier, it's not just about what your child needs, but what's going on with your district is going to determine quite a bit as to how you would proceed. I mean, we live in California, and I live in a really tiny school district in a rural area. And a lot of parents I know through our TACA group live in Southern California, and their districts are very big and have very sophisticated people who run those special ed programs. So their responses they're going to get to requests are going to be really different than is going to happen in my farming community. Okay, first thing we need to know before we decide what to do, what types of programs does your district typically offer? Okay, and this is important for those of you whose kids aren't already in school. Because if your kids are already in school, most of you already know, but some of you who have kids who are 2 years old, you don't know. Because we need to know before you even start the process of trying to get that, what do they typically offer? And then parents often are always asking me, why did the district do this? Why do they do that? Why won't they give me this? Districts are reactive. They're trying to figure out what you're going to do. There often is absolutely no rhyme or reason, okay? Because the fact that you're at Autism One means that you're an exceptional super parent, okay? And districts don't know what to do with you. So a lot of times, the problem is they don't know what to say to you. They're trying to put the brakes on. Because sadly, most of the parents that I talk to, 90% of them, they don't know their child's rights, and lots of them are really happy with a special day class. They don't know that something else could be, and really that's kind of judgmental, because I don't think the special day class in my district's very good, but other people are okay with it. So the thing that really mystifies your district is, why are you so unhappy with what everybody else seems to think is an okay program? We're also going to have to consider, if you're going to be successful in getting one-to-one, which I should have said this, but I'm going to assume that a good one-to-one program is not the norm for your district, okay? So what we're going to determine is, why is a district's program inappropriate for your child? Okay, is it just because it's generic? Is it just because it's eclectic? Is it just pretty much a babysitting program from 8 o'clock to 2 p.m.? And this may seem obvious, but how is the district's program different from what you want? Okay, because there are districts that do ABA at school. The kids are in little cubicles. And as far as they're concerned, they're putting on an ABA program. So we have to build a case to say, how is that different than let's just say you want a home program, okay? So you have to build a case on little things. Like, my child has enormous maladaptive behaviors. He screams, he tantrums, he bites. Well, in an ABA program, you would use extinction. You can't use extinction in a classroom. In a home program, if my kid wanted to cry for an hour, the tutor would just sit there and take data and keep looking over and saying, done yet? You let me know when you're done. You can't do that in a classroom. So there can be really good reasons why a child like that needs to be in a home program for at least for a certain amount of time until he's achieved those skills, so we're not having those hour-long tantrums. Other thing is, ask for more than you want. The problem a lot of times with negotiation with school districts is it can get really personal. And people don't want to give you things because they just don't want to give it to you. And they feel like you're nibbling. If we give her that, then Mrs. Arnold will be back, and she'll want this, she'll want that, which is true. So the thing is you want them, since this is really about people, it's about personal relationships, you want them to feel like they won something too. And, they gave you an IEP offer. You rejected it. And then you come back and you want all this. nobody is ever going to give you 100% of that. So please do not ever ask for the only thing you want, because chances are you're not going to get it. Okay, so sometimes part of the strategy, and this is what we did for my son when we went to due process, which by the way settled, so I'd never actually been through a hearing. Tim advised me that we were going to assess in all areas. Spencer was doing really well in speech, okay? But we got it all done. We had the psych do an assessment. We had a behaviorist do the assessment. We had an OT. We had a speech and language pathologist. We did everything. Because when we went in there, we were asking for the sun, the moon, and the stars, plus my attorney fees, okay? If we hadn't done that, there would be no place to negotiate, okay? Plus, we prioritized it. Now, the ABA, the one-to-one services, that was the big ticket, and I'll tell you why. And this Perlman kind of touched on this earlier. Because it would be an agency delivering it, okay? And OT was right down here, because no matter how much OT they gave me, it would still be that stupid woman from the OT delivering the program, okay? She also got to be realistic about it. Who's going to deliver the service? And then you can weight it as to what would be the most important and delivered by the right people, okay? Because that was like the whole Sylvan thing that he was talking about. You can fight for somebody, but if it's just going to be a loser who's going to implement it, what did you ever win out of going through that? Okay, so that's why one-to-one can be the most important, because if you can get an outside agency, which I'm not saying all agencies are good, you can often make a much bigger difference, okay? And a lot of that will depend on where you live. In some places, some people have great choices for outside agencies for speech and language. So that might be the really big thing to go, or they live near a really great Tomatis center or something like that. So you want to ask for more you want, and you've got to be prepared with the evaluations. And then timing. And this, again, goes back to the whole poker thing. Lots of people go around telling the district that they're going to file for due process and they're going to do this. Well, you don't want to do any of those things until you're ready for it. Okay, the last thing you want to do, if you're going to do this, sometimes people do this on their own, they file for due process, and I think, you're crazy. How can you go to due process? You don't have any independent evaluations, you don't have an expert, just who was going to testify to say that this is what Johnny needs, okay? So the whole time we're thinking about the process of getting ready to show my program's appropriate, the school district sucks, he didn't make progress so far, he doesn't, my expert says, if he didn't make progress in the last year, it's really unlikely, not probable that he's going to, okay? And everything's on it. We have all the experts, the child's been in the program for 3 months, we've got the data, like Dr. Perlman says, we changed the trajectory, okay? So these are kind of the things that go all together so that you can be ready and you can get the more leverage out of the entire process than someone who's just following kind of a cookbook directions as to how do you present a case for your district to give you one-to-one behavior services.
I'd like to comment on the asking for more than you want. Keep in mind, for school districts, this is always a negotiation. And I encourage parents that I talk to not to negotiate in the IEP process. Take it outside the IEP meeting, okay? Don't show the district that you're going to compromise in the IEP because you're going to ask for everything you feel your child needs. We're not telling you to make things up. If your child probably does need more speech and language, but parents often say, if I ask for too much, you're going to think I'm, demanding and unreasonable, and they're not going to give it to me. Well, keep in mind that if you do ask for everything you feel that your child needs, they're going to counteroffer you anyway at some point. They're going to want to bring you down, and probably you'll end up maybe, they want to get you down at maybe half of what you've asked for. So you're not asking for unnecessary things or things that are frivolous. You're asking for things your child really needs, but keeping in mind that they're always going to want to negotiate because all these things cost money, and they require staff, and it's not always convenient for them. And in California, we've got a shortage of speech and language pathologists. So what we've seen recently is that the speech service recommendations have gone down. Yeah. And that's not a coincidence. There's not as many speech paths. It doesn't mean the child doesn't need speech. So that's what you need to keep in mind, that it's going to be a negotiation. It's a business transaction in many cases for the school district, regardless of what they tell you.
And I would say, too, is that keep it framed with your district. It's actually not even what you want, because I'm hoping that you will have gotten independent evaluations. So deflect all that. If people love to ask me, what do you think we should do? What do you want? And I don't know. Should we call Dr. Perlman? Should we call Dr. Fosnot? You're going to refer them so that it doesn't become mom wants everything. Look, I consulted with experts. They're saying he needs this, and it's based on this research, and that's what you're asking for. You're asking for evidence-based practices for your child.
Very good example, and Lynn already brought this up as an example in her son's IEP just this week. And the example was that we had requested a particular methodology that was research-based and peer-reviewed, and the school district's response was, we don't really have anything available in the district. We don't want to provide that because it's not available. And then they came back saying, well, we don't think that it's necessary for the child. So we turn it back on them and say, well, what are you going to provide? What research-based method of instruction are you going to provide to target this area of area deficit? What are you going to put in place if you don't feel mine is necessary? Okay? And you also have an expert to say, and this is the information that supports our position. This is the university study that shows that this method of instruction is research-based. You've got this expert there to help you through this process. So it's not just you being demanding, you're asking for a program that you happen to see on the internet in a Google search last week, okay? This is something that you've hired a professional to help evaluate and determine, based on this professional's recommendation, what this person truly feels your child is going to require. And remember, just be careful using terms like best or maximize benefit. It's always going to be appropriate for my child, okay? Regardless of, district's always going to come back if you use terms like best, this is the best program. Obviously, we want the best. You want the best for your child. Your expert wants the best. Your advocate, your lawyer, everybody wants the best. But you always have to characterize it as the appropriate program, okay? Because it's very subjective. You've got them telling you they think this is a free, appropriate public education, them being the school district officials, and you've got your experts saying this is what we feel is appropriate. So they're really, it's really up to the IEP team in theory to determine what's appropriate, and what ultimately it comes down to is whether the school district feels you've got enough evidence to show that the program that they've offered is not adequate, and you can take this case forward and prove that what you've asked for is not only reasonable, but it's appropriate, and it is tailored to meet this child's unique needs. Okay, so we're going to go back. We're going to hit this really hard, the need for an independent evaluation. It's going to sound redundant, you've heard it before, but it's imperative that if you're going to ask for a one-to-one behavioral program, whatever method of instruction that you choose or you feel is appropriate for your child, that you have some expert to substantiate your request. This person is going to need to do an evaluation that may include formal testing and probably will include observations. A lot of the things that Dr. Perlman had already discussed, put it in a report, attend an IEP to discuss this, and give the district an opportunity to respond. So it's important that that's your starting point. If you just say, my child has autism, he needs an ABA program or needs a one-to-one behavior intervention program, the district will try to sell you something that they've got already in the district. They'll try to sell you their model autism program that they spent hundreds of thousands of dollars developing with the consultant that they've hired. Okay? Well, you know, I don't really think it matters. That's a good question for Dr. Perlman. But in our experience, as long as this person has expertise in developing educational programs, whether they're an educational psych or a clinical psych, you know, it really hasn't mattered as long as they've got the requisite experience and background to understand what we're developing here. If we're looking for an ABA program, you want to get somebody who's a behaviorist, okay? Not necessarily somebody who works for an agency, but typically Dr. Perlman will do a certain type, you know, and you can answer this, Mitch, but he'll do some of the testing, and he'll say, you also need to see, you know, Dr. Smith at this agency or somebody else. Here's a list of people who are behaviorists who put on ABA programs. That's their specialty. So we're going to have, just like Lynn had mentioned, we're going to try to cover the gamut of areas of suspected disability by getting all these reports and being prepared to discuss all these areas of need. And whether or not you want to prioritize and say, hey, speech is kind of on the low list of priorities, I really want to focus on the most expensive component of this child's program, which is it's usually one-to-one behavioral services component, that's fine, but you need to cover all your bases and be prepared to go forward with these reports and hit them all. And then, you know, like I said, don't do the negotiating in the IEP. Don't show the school district that you're willing to compromise your child's needs in the IEP. Make the request based on all those reports. Again, you're not asking for something frivolous. You're asking for something that the expert has clearly delineated as something necessary for your child, but it's up to you outside the IEP process if you want to go to a resolution session or a mediation, or you want to have an informal confidential discussion to discuss settlement with the school district. That's fine, as long as you're getting what you feel your child needs. Just make your request official in the IEP meeting.
One thing I wanted to address, you said about choosing who that person is. One good way to do it is at most state education websites, they have a listing of prior due process hearings. And what you can do, so if somebody says, like, let's say, Dr. Smith is the go-to guy for your state, then look to see all the due process hearings in which he's testified. Because usually when the hearing officer goes through and says how they decided, they could say something like, well, Dr. Smith was not credible for these reasons, or he was, because they're going to compare which were more credible, the school psych or the independent psych. That can be a good way to go see who's the go-to person. And then, of course, there's always your parent groups, which somebody, I think, had asked something about that. I would recommend, if you don't already have a parent network in which you can ask who the experts are, I would go to Yahoo Groups, and you need to find the autism group for your region or your state and ask, because you should be able to find I want you to find a good expert, somebody that other parents have told you about, somebody who might even give you a sample report to look at, so that before you invest that kind of money, you feel really comfortable that this person, and talk to them too, and just tell them, this is what we're looking for Johnny. Is this something, do you like ABA programs? Because we want somebody who likes ABA programs to do this, because if they don't, if they say, oh, I love structured preschools, hang up the phone, okay? Because the last thing you need is to get an independent evaluation for a structured program, whatever that, preschool, whatever that means.
You may not always agree with your independent expert, and I think that Dr. Perlman touched on that, right? He hit it very well. If you don't like the recommendation, if you do it as a confidential assessment, not an independent evaluation, you may be able to, quote unquote, bury that report at some point. There does come a time that you may see that report and you don't agree with it, but it's harder once it's already been characterized as an independent educational evaluation, and typically it's a good idea to give notice that you're going to do that and to have some level of confidence in your assessor. You can't predict the future. You don't know what they're going to say. He may say something you don't like, and it's still possible to cancel that assessment before it's completed. It could become problematic, because if they already know you're doing it, then the school district may question it. I don't see that happen as often. If you know this person has worked with a lot of parents of children with autism, and you kind of know how they have testified in due process, obviously every student is going to be different, but what I've seen most of the time is that the recommendation comports somewhat with what the parent was hoping to see, but you're not buying a recommendation. You understand that this person is going to give you, if he's good, he's going to give you an independent, credible opinion. And the reason why it needs to be credible is because when that person gets up and testifies in due process, he can't be blowing a lot of smoke for the hearing officer, because hearing officers can see through that if there's someone experienced. All right? They can see if the guy's just a hired gun and is not really giving an accurate description of what this child's needs are, and just essentially telling the parent what they want to hear. You want somebody who's going to be honest with you.
Another thing that you can do too, since we're often talking about a big chunk of change when you're doing an assessor, a lot of times I'll tell parents, talk with your assessor after they've done the observation, also to do the testing. Because if you have something specific in mind, you want this assessment because you're going to do process, because you want A, B, C. That person probably has a really good sense, after they did the observation, after the testing, what they're going to recommend. So if you have a conversation with them and you're not agreeing at that point, with a lot of assessors, you can just say, why don't you just bill me for what you've done so far? Do not write a report, okay? Because I think Dr. Perlman will tell you, doesn't it take a lot longer to write the report than it does that day of testing, okay? So if somebody were to tell somebody, just bill me for what you did today, that would be a lot less expensive than shredding his report. Okay, so that's kind of two different perspectives, how he tells you to find his perspective as an evaluator, and what I want to know as a parent. I only have so much money. Go ahead.
How much money do these assessors?
You could spend anywhere from $3,000 to $10,000. Sometimes people tell me about they spend $1,000. I really wonder what you could get for $1,000, because usually these people are highly qualified and they're spending a lot. I mean, it takes a lot of time to spend because it's hard to do a meaningful evaluation, we spend a lot of time doing evaluations and then actually administering the tests. And I would hope that all your evaluators, especially since it's something educational, like Dr. Perlman talked about, usually with autism you want to see them at school. And if there's a dispute over placement or programs, you want somebody who's going to go see the district's either current program or proposed program. Even if you think it's worthless program, okay? Don't ever not go see a program that your district recommends, even if everybody's ever told you that it's the most worthless thing ever. You and your expert need to go and see it, and then you can say precisely why. Yes, thank you, I did go see it. And everyone in this class already has whatever, and it was crazy, and my kid imitates, and I can just see my kid would be a flapper after 2 hours in that class. Whatever the thing is, then you can say, and your expert can say in their language as to why it would be inappropriate for your child.
Keep in mind that if you're going to have an independent expert do an assessment, a thorough examination of your child, and you're going to take this to due process, and there's a possibility that you won't agree with the school district's offer, or you're ultimately going to pull your child out, you have the burden, if you're going to seek reimbursement from the school district, to prove why the school district's program is not appropriate. Okay, and it's hard to do that if your expert hasn't seen their program. You're just guessing. And why your program, the program that you've selected, is appropriate. Why it is meeting that child's needs. And usually, as both Dr. Perlman and Lynn said, based on the level of progress this child has made. If you've had him in the program for 90 days and the kid was regressing or plateaued in the district's program and you switched programs and you saw a tremendous amount of progress, that's great evidence to show why the program is appropriate and in comparison to what the district was doing that wasn't meeting his needs.
The other thing is, go see it, but I don't mean necessarily put your child in it, because I hear that all the time too. You know, the parents get pressured, you know, they're being unreasonable. Why won't you try it? Won't you try it for, 90 days, a month, or whatever? Now, there's two problems there. Number one, you love your child. Why would you want them to put them into any setting that you just thought was wholly inappropriate, okay? Because although it might make for a really great case in due process if your child has a nervous breakdown in that classroom, okay, that's not the way you want to win your case. We don't ruin the kid first so that we can fix them later. Secondly, some school districts, in fact, a lot of schools are dishonest. And if you put your child, there's three reasons, the third one's going to be next. If you put their child into the program, they will create data to show how appropriate it is and how this, before they were saying that he was really rotten, but now they're saying everything about that program, he's just thriving. It's just beautiful. He does everything he's supposed to. He's meeting all his goals. So you took a pretty good case, and now it's not a very good case anymore because now the district has an incredible amount of data that they're willing to testify on, okay? Third reason why you wouldn't necessarily want to try an inappropriate placement is that could become your child's stay put, okay? So if you have your child in a placement that's currently okay for your child, don't try a district's program just so you can be reasonable, unless they're willing to put a sunset clause on it to say, yes, I will try it. But it says right there in the IEP, is if after a month I'm not happy, that the previous placement will become Johnny, Susie's, whatever, stay put placement so that you don't get stuck, because then your only alternative will be, if that placement is horrible for your child, is you will just have to pull them. Keep them at home, put them in a home program, but that doesn't necessarily work for everybody because a home program can be expensive and some parents aren't prepared at that point to start funding the home program.
Yeah. It's very important that you're ready to file for due process before you file. You've got these experts, you have this data, you have this information, you're ready to go. Because if you file just because you want to try to gain some leverage and the district calls your bluff and decides, hey, let's take this parent to due process, and they force you through really quickly, you're not going to have the information you need to prove your case. And there's a very good chance you're going to lose your case.
In some cases, you can even get a date for due process in 2 weeks. I don't know about you. I mean, due process is a big deal. There's hardly, how could you get, even if you already had an attorney, it would be very difficult to build a case within 2 weeks, even to coordinate getting anyone to evaluate your child and provide any data, whereas the school has the school has people just ready to testify on their behalf. You don't.
Something else that's very effective in gathering information in preparation for a due process hearing or to substantiate your request or to gain leverage are videos. If you have before and after videos, I know Dr. Perlman mentioned, take lots of video of your child from day one in the program to show the progress. Hearing officers like to see that. And I won't say that necessarily at this juncture that hearing officers in our state of California are experienced enough to understand the significance of some of these changes.
Right.
But I think it is important that you have that evidence, because if you don't like the hearing officer's decision, you get up to a federal court or a state court, I think it's going to be very compelling.
There's another reason why you really need to have the video, is that besides the fact that it shows the progress, a lot of times the school's argument is, let's just say this is an older child. Let's say he's in 2nd or 3rd grade. The thing the district will often say is, sure, you brought in Dr. Perlman. Sure, he has qualifications that exceed, but he doesn't know the child. We have known Johnny for, maybe even 5 years at that point, if Johnny's been in their preschool thing and he's in 3rd grade now. Okay, there's no comparison. The other reason that you do video is because if you did 100 hours of video for Dr. Perlman, you could give it to him and he could fast forward through it. And he could watch all the pivotal points and he could say, I've watched this kid for 30 or 40 or whatever amount he really has watched. He might have skipped through some of the areas. And that's how you can also build a case for how well does your expert know the child versus the district, who is saying that they know 5 years of Johnny and he knows maybe 1 or 2 weeks of Johnny.
Let's talk about how this one-to-one behavior program should look. Once you have this independent assessment in place, it needs to be specific. You need to have a very detailed description of what this is going to comprise of. You don't want to have a report that simply says, Johnny needs to be in an ABA program or to have behavior intervention services for 40 hours a week. That could be misinterpreted in a number of different ways.
A structured preschool.
Okay? Structured preschool, 40 hours of behavior intervention, and that's not enough. Okay? We need to know all kinds of things, and you'll see in your workbook, I'd like to know, assessor needs to describe with as much specificity the following. The setting, is it going to be an in-home or a community-based program? Is it going to be clinic-based? Are we talking about something that could take place either at an agency or at a school-based clinic? Is it a school-based program in the sense that is it happening in the classroom, as Lynn had described? Some of these school districts will put a child in a classroom, children in cubicles, and they'll do, say, a discrete trial training with them in the cubicle. Or is it going to be delivered in a variety or a combination of different settings? So we need to know what this independent evaluator's opinions are so we could have an educated, a meaningful discussion with the IEP team and with the district and be prepared to address their questions. So when they say, yeah, we can provide ABA, well, what's the setting? Where would you provide it? Maybe the school setting is not the most appropriate setting for Johnny. Okay, maybe the clinic-based program is not. Okay, maybe it needs to be in a natural environment like the home. Okay, this all needs to be in that report. Type, duration, frequency. We need to know specifically how many hours. And again, the 40-hour generic recommendation of what are we talking about? Does that include supervision time for the supervisory behaviorist in charge of the program? Does that include meetings that you'd have on a monthly basis? Clinic meetings, as they're sometimes called? How much of this is one-to-one for the child, just with the behaviorist or the tutor/therapist and the child? So that's also important. And of course, once you have that, you're ready to present your recommendations at the IEP. You give your report to the school district official, whoever is in charge. Sometimes they're called program specialists, sometimes it's the principal, sometimes it's the psychologist, the case carrier. Whoever that person is, your primary point of contact with the school district, make sure they've got a copy, make sure it's in advance, well in advance of the IEP, and make sure that they've read it and had an opportunity to digest it. It's up to them. If you give it 2 weeks in advance and they still haven't read it when you get to the meeting, then, arguably they've committed a procedural violation by not considering that assessment. If they just want to consider it in the context of an IEP, it's not enough to sit there and just read the report. Give it to them in advance, give them plenty of time to review it, and have your expert, your independent evaluator there to discuss in detail and to answer questions about these recommendations. And if that doesn't work, if you presented the recommendations of the independent evaluator and the district is still saying, look, the program that we offer, we feel appropriately addresses Johnny's needs, therefore we don't agree, we've considered the report as is our legal obligation, but we're going to put him, or we'd like to place him in our autism-specific program in a special day class or in a clinic-based setting when you've asked for a home program, a home setting based on your assessor's recommendation, then your next step will necessarily have to be file for due process. Unless unless you're a parent that would like to pay out of pocket for the program. But most parents are not in a financial position to be able to do that at anywhere from $5,000 to $10,000 a month, depending on whether it's done by an agency or partially done by the parent as the aid. You know, there's a variety of different combinations of options that you can do, but you know, most parents are not in a position to financially afford the cost of an ABA program, and it's imperative that you be prepared to take the next step. But of course, weighing the cost-benefit, you've got to look to see how much it's going to run you to litigate this case, and just plan on litigating it all the way through to a process hearing. Find out how much it's going to run you to do that, and pay attorney's fees versus, you know, the likelihood of success. I mean, you can't predict with certainty what the outcome is going to be, but you have to prepare for the worst, expect the best, and just, you know, work with your lawyer, whoever that, somebody that knows special education law, on trying to get set up and be put in the best position to litigate this case and hopefully win your case.
But you have to remember, at this point, you're still playing poker, okay? So a lot of times parents will say, I know I'm all ready, but I still don't want to file for due process because I can't afford it, okay? Well, filing for due process doesn't mean you're going to go to a due process hearing, because at this point, you can still bluff. And sometimes that can be very effective, because that when you finally file for due process, you show the district you're totally ready, they have the reports, that can often be the point at which your district is finally ready to negotiate. Because since you're playing poker, you don't know what their hand is either, and that might be the time that you can go into mediation, you can go back and forth with them, and walk away with a program that you're willing to live with. Because most of us end up paying for some part of the attorney fees in the end, even no matter how right we were in the beginning, but do get what was substantially the most important thing for our child, so that now they can make progress in their program.
Okay, it's easier to play the bluff game when you got the ace on the table and everybody can see it.
When you're
There's a
ready.
good possibility you're going to have a great hand, because the district can see that you've got this independent report and you're prepared, if necessary, after that filing has already gone out to the agency that here's your due process complaints, that you're prepared to move forward. Even if you don't intend to, if you've got that report in hand, it's a lot easier. I always want the parents I talk to and my clients to be prepared, because you don't know. The district could decide to call your bluff, and you don't really have a good, necessarily, the money in the sense that, you know, that diminishes the value of your hand, because you don't have $30,000 or $40,000 to pay for a due process hearing. But you need to be aware that it's important that the school districts understand that you're prepared to take it all the way.
If the school district calls it bluff,
Yes.
what do you do next? In other words, let's go here, you can't afford it.
You look. There's lots of options. It depends on what, if you can't afford it. I mean, are you looking at paying for it cash? Are we talking about credit? There's no source of possible funding. I've had parents that come to me and say, I can't afford this, but what they've been doing is they've been spending their retirement savings, and it's been depleted. You know, there's a possibility in some cases that the parent can look at other options, maybe taking out an equity loan. I mean, it depends on, again, the cost benefit. How much risk are you willing to take to try to get this program for your child? If it's going to cost you $40,000 to get a $10,000 program, you know, is it worth the risk? Probably not.
But I think what he's asking is, how do you call it quits, though?
Okay.
You don't have the money, you can't get it.
Mm-hmm.
What do you do next?
What about using the
It's
conflict resolution process? Illinois is
Sure.
a state that has a free, no charge to parents, no charge to school districts conflict resolution process.
okay. There's not a good. Let me answer his question first. There's not a good answer. Unfortunately, if you really can't do it and they call your bluff, then you may not have a choice but to withdraw your complaint, or to, you know, possibly consider moving to a different school district that might be more friendly to parents. That is all, you know, it's all relative to who's being employed in an administrative position and who's running the show in that school district. I've had parents call me all the time saying, I don't want to go to hearing, I don't have the money. What school district should I move to? You know, where should I, you know, buy a condo and move my family? Or should I split the family, so to speak, and have, you know, dad live with, you know, a couple of the kids, and then mom goes and lives in a different area, actually lives there. We're not talking about, you know, somebody that's pretending, because that's fraudulent. You want to make sure that you're actually residing in that area, but, you know, that's some sacrifice that parents are willing to make. That's another consideration, but that can also change with a director of special education or an administrator or whoever's in charge of special education changing, becoming, she gets fired or she leaves her job or gets promoted, and all of a sudden the very ABA-friendly district or district that was willing to contract with a number of agencies to provide these services becomes the very unfriendly district to parents. So, you just have to look for other options. If they call your bluff and you simply can't afford to pay for the program or go to hearing, then you have to look outside and see, hey, is there a better district we can go to?
The other thing, too, that I wanted to point out, one of the reasons, too, that sometimes parents have to file for districts, there's some districts who really will not negotiate on anything. And sometimes it's for a really specific reason. Like, I'll give an example that somebody else had told me about, a district that they won't give certain kinds of placement unless the parent will negotiate. Well, you can't negotiate in an IEP. You can't say, well, if we let your kid go to the private school, you'll have to drive it, because they have an obligation to provide transportation. However, if the parent is willing to push hard enough and file for due process, and then you can go into settlement talks in mediation, well, now everything's on the table, and your district can offer you something that could never fly in IEP, okay? So in that district, the district is waiting to see what is the parent going to do. And that's the way. There's not going to be any parent who's going to get a non-public school placement because it's too expensive to provide transportation in that district, okay? So there's lots of different reasons why, because sometimes parents are trying to make sense of what the district does on their sides, and for that district, it actually works out pretty well, because they don't want to go to due process on most of those kids who do it. They would place them, but it's too expensive. So those are some of the reasons why you would take it that far, or even you said conflict resolution, that can work in some, or sometimes the district will offer to go into mediation, and sometimes that can really work, because you can talk, both sides can present what they'd be willing to offer on both sides, and you can kind of go back and forth until you come up with something that you can live with.
When we get to advanced strategy, we're going to talk about how to prepare for these IEPs and to know your district well. So along the lines of your question again, if you know what your district has done with other cases, you know how many times they've been to due process hearing, you know how many they've won or lost, you can find out if they're really going to call your bluff, or if it's just a bluff on their part, saying, hey, we're not going to work with you. Are they a district that settles cases, or do they litigate everything, and what is their success rate? Okay? You can find that on the internet. Just type in, look for administrative hearing decisions, special education for your state, and find out, if they say they're going to call your bluff, are they really going to take you to hearing? If they haven't had one hearing decision in the past 5 years, it's probably because they've been settling every case. Or either that, or parents just aren't filing for hearing. But it's likely, it could be a combination of the two, but if it's a district, we've got lots of school districts in California, and usually a district not having a lot of hearing decisions is an indication that cases are getting resolved. And this lady over here talked about resolution. It could be at a resolution session, okay, under the IDA 2004, within 15 days of the parent's due process complaint having been filed and served on the school district, the district has to convene a resolution session. And they have to meet with the parent to discuss the issues. All right? And there's also the option for mediation. If the parties aren't able to resolve it then, the parties can opt to go to mediation. That's a voluntary process. Either party can say, I'm not interested, let's just go straight to hearing. Resolution is not voluntary, at least per the 2006 regulations implementing the IDA. There was some question about whether we had to go or whether it was an optional thing, and the regulations clarified that it's mandatory if the parent wants to continue litigating their case. They wouldn't be able to take their case forward unless they attended resolution session. So that's an option. But do research on your district. Know who they pay for in terms of agencies, if they pay for anybody. Know whether they use in-house behaviorists, and know to what extent are these people really qualified. So if they want to call you you can call their hand as well. Come back and say, hey, I know you haven't litigated anything in 5 years. We got a good case. We got an expert. And how are you going to prove your case? I think you're going to spend a heck of a lot more money in due process than it's worth it for you to move forward on this case and litigate against us. I think it's a lot more cost effective for you to just pay for this program. If they want to do it as part of a confidential settlement agreement, and I can discuss this with anybody that's interested, confidentiality, not always binding, especially when you're using public funds. In fact, it's usually not. At least that's the court's interpretations in California. But if they want to do it as part of a confidential, and you're okay with confidentiality, they're still going to dish out the money to pay for that program, it might be okay with you then. I mean, usually with most parents, it's not. Confidentiality starts as an issue, and it could be principal. But in the end, if they're going to spend the $40,000 on the one-to-one program, it may be worth it to agree that the discussions are confidential. Because if you settle in mediation, the mediation is by statute a confidential process anyway. So there's lots of things you can't discuss if it didn't settle because there were settlement discussions, and they wouldn't be admitted as evidence in a due process hearing or in a subsequent proceeding in court, because that's just public policy. Courts don't allow that stuff because they want to encourage parties to work together. They want to encourage parties to discuss settlement and not to have one or the other party using compromises, offers to compromise against each other. They're usually under contract with the Department of Education. So if you look up your state's Department of Education, they should have a database to allow you to research prior decisions. And in California, for example, you can put in the school district, and sometimes you can even put in the issue. Now, I don't know how...
It searches by keywords. You can put in any word. You can put in the name of your expert, your school district.
You can find out all kinds of stuff about your school district just by researching the hearing decisions. Mm-hmm. You're talking about eligibility, just for any IEP? Right. I mean, it's the same process. In almost every situation, you're going to want to have this independent assessment to substantiate, in this case, an issue of eligibility. What qualifies this? Why is this child qualified? Why does his disability substantially impact his ability to perform academically or socially or in a school setting or in any sort of educational setting? All right, to what extent is that going to impact his ability to perform? I mean, eligibility can be a very subjective thing, okay? And under IDA 97, there was a discrepancy model that could be used. It was still somewhat flexible in terms of, I mean, a team can still get together and say, we feel based on this criteria or these reasons that he meets the criteria and he is eligible under that category of autism or autistic-like behaviors. Yeah, 504 is like second string, okay? You always want to play your first string person, and if you can play them, you're going to play them to win the game. But if he's injured or you're towards the end of the game, maybe you don't necessarily, you put the second string guy in, okay? You don't want to accept a 504 plan if you don't have to, okay? You're talking about a child that clearly only needs reasonable accommodations. It's very hard to track progress. You don't necessarily have to have goals, that are very specific. It's just a very kind of touchy-feely, they call them student study team meetings. I mean, there's a lot more procedural protections in the IDEA, a lot more substantive law that would provide you a greater benefit if you try to get eligibility determined under IDEA as part of an IEP. So, not a big fan of 504 unless we're talking about a child who's pretty high functioning, very mild. There are some circumstances where a child on the autism spectrum, a 504 plan would be perfect. Obviously, the goal is to exit the child from eligibility altogether. We want to provide such an intense amount of intervention that this child doesn't need an IEP, that he's amongst his typical peers all day long without any supports. Mm-hmm. It's amazing how the story changes when you suddenly have.
That's why you have to document.
Yeah.
That's why you have to
Right.
stay on top of your documentation, because you can say, well, what happened? This. What are we doing about this? And then, of course, that's also time for somebody else to come in and do an observation, so they can say what he is or is not doing in the classroom. Yeah, a behaviorist. You had a question right there.
Does the attorney fee provision apply for the due process hearing? That is, a prevailing party gets the attorney fees?
That's correct. Prevailing parent can collect their reasonable attorney's fees as part of costs. And depending on your circuit, there's different interpretations of what prevailing party status means.
And just following
Sure.
You had said that we should ask for the sun and the moon and the stars, and if you get half of it, are you prevailing?
Well, she was talking about a settlement situation. If you're talking
Yeah.
about due process, if you're going to take an issue to due process, you better be able to substantiate why you're asking for the sun and the moon and the stars. I'd say still ask for it, but if you're in a circuit where they're going to proportionalize the number of issues that you win to, and give you your fees based on that proportional number of issues you prevailed on, it may not be worth it for you to litigate for the sun, the moon, and stars. You could ask for it as part of a settlement discussion, or you can ask for it in the IEP and make sure that it's clear, but that doesn't mean you're going to make an issue out of it in due process. It may not always be to your strategic advantage to do it that way, depending on how your circuit interprets the prevailing party status. Just give you an example, some circuits may say, hey, you won 50% of your issues, we'll give you 50% of your attorney's fees. We don't live in California in a circuit that says that, fortunately. We went on a significant issue, something that materially changes the position of the parties. You got something tangible out of this. Your child, you got something for what you went to hearing for. It's not something de minimis, okay? The result is somewhat favorable to you, whether or not you won every single issue. It's not required. So they don't proportionalize those fees. What?
We have to stop. And go
Okay,
on for
so
comment.
we're on to our next session
Next one is
6,
Perlman.
building a framework, and we're going to go back to Dr. Perlman. Again, we're going to address as many questions as we can. If we don't get to the questions, feel free to email me, and you can go to our website, take a look at the website, and there's a link to my email address or info@edattorneys.com, and I'll do my best to get back to anybody's questions or have somebody from my office get back. Okay, we're going to give everybody, we're going to switch mics and computers. We'll give everybody about 3 minutes to take a break.